What if your parents need long-term care immediately? The bills are starting and you have no plan into place. Can you still protect some of their savings? In this video, I'm going to talk about crisis planning, the critical steps that you need to take, and the tools that an elder law attorney can provide to help you protect your family's assets. Hi, I'm Brian Menzie. We've been helping Missouri families for years protect their assets and plan for long-term care. If you want to make sure that your estate plan and future decisions are secure, call us at 636-456-2345. Most people have heard of long-term care, but few understand what crisis long-term care planning actually means. So let's break it down. What is crisis planning? Crisis planning is what happens when somebody needs long-term care right now or in the very near future, and there has been no advanced plan put into place to protect those assets. Maybe mom fell and now needs nursing home immediately. Maybe dad's dementia has progressed to the point where he can no longer stay at home and be safe. The need is urgent. The costs are enormous because they can be between $7,000 to $10,000, and the family is panicking because now they don't know where to go and where to turn. This is the situation that walks in more often than not into our office. And the first thing I tell every family is this: it's usually not too late, especially if the person still has capacity. Unfortunately, if the person needing care is incapacitated and they have done nothing or had a general practice attorney create some of the documents, it becomes much more challenging, and quite often our hands are tied. Crisis planning uses specific legal and financial strategies to help someone qualify for state and federal benefits as quickly as possible, even when care is already needed, while protecting as much of the family's legacy and savings as the law allows us to do. Without this kind of planning, unfortunately, most families end up spending nearly everything that the family has amassed over the years by paying out of pocket that $7,000 to $10,000 a month before any other assistance kicks in. Now, here's where timing matters so much in a crisis. The thing that a lot of people have heard is about the 5-year look back. What is the 5-year look back? Basically, what the 5-year look back means is that the state and federal government can look back in your finances for the preceding 5 years. If you've given away anything and not received something in return, like you can't give it away to the church, you can't give it away to your kids, that 5-year look back is really important. And they will scrutinize every one of those transactions. And if they find something that is considered a gift, it can trigger penalties that delay eligibility. And when somebody already needs care, those delays can be devastating. That's exactly why you need an attorney, an elder law attorney, who understands how the states and federal rules work and how you can put together a plan that does not cause catastrophic financial distress. You want somebody who is not guessing. You're not relying upon an online article, but someone who does this every single day. Because in a crisis, one wrong move can cost your family tens of thousands of dollars. Also, keep in mind that every state has its own set of rules, so this can get confusing quick. What are the steps you need to take immediately? When a loved one suddenly needs long-term care, everything feels urgent. And by the way, it is. But there is a path that you can take if you know what to do. The first and most important step is to consult with a qualified elder law attorney. Do this immediately, not next month, not next year, not after you've tried to figure it out on your own. Right now is when you do it, because an experienced attorney can assess your family's specific situation, explain what options are available, and build a customized plan to protect as much as possible given your existing timeline. The second step is to evaluate asset protection strategies. Even in a crisis, there are tools that are legal that can help shield a portion of the family's savings. Depending upon your situation, an attorney may recommend creating certain types of trusts, restructuring how assets are held, or using other strategies that work within the rules and the laws of the state and federal government. Every family situation is different, and the right strategy depends upon the specific assets, the timing, what has been done previously, and the needs of care. Third, you need to understand how eligibility actually works. There are strict income and asset limitations. While one might affect it, the other one might not. There are rules about what counts and what does not count. There are transfer rules and penalty calculations. Most families have never dealt with any of this before, and the system is not designed to be easy to navigate. It's intentionally designed to be complex. An attorney who primarily handles this area of law can help you avoid the most common mistakes that delay or even disqualify an application. Fourth, gather the documentation. The state requires a lot. We're talking a lot of documentation. They need up to 5 years worth of financial statements, bank statements, investment account statements. They need the deeds to the property, insurance policy records, income records. Having this information organized and ready can help dramatically speed up the application process, because without the proper documentation, an application will be denied and you will have to start over while the bills keep coming in because they're not on pause right now. And fifth, make sure the right legal documents are in place. If your loved one doesn't already have a financial power of attorney and a healthcare directive and a healthcare power of attorney in place, these need to be established as soon as possible. Not tomorrow. They need to be done today. No one in the family can make decisions on their behalf without these documents. You could end up in court on top of everything else. And when you end up there, you will probably end up being unable to protect any of the assets. How estate planning and asset protection work together. And here's something most people don't realize. Estate planning and long-term care planning are deeply connected. They're not two separate things. They work together. That is how and what an elder law attorney's area of expertise is. A solid estate plan doesn't just say who gets what after you're gone. It also builds protections for exactly this type of situation. When somebody already has a trust, power of attorneys, and a clear plan is in place before a crisis hits, the process becomes dramatically simpler. The legal authority is already established. The assets are already in a position to be protected. The family isn't starting from zero during the worst week of their life. But even when there's no prior plan, estate planning tools can play a critical role during a crisis. Creating the right documents and structure during the application process can mean the difference between qualifying smoothly and facing months of delays and penalties. The families who come through in the best shape are the ones that get professional guidance fast and let someone help them coordinate the legal and financial pieces together. We've had clients who have tried on their own and were denied not once, not twice, not 3 times. We've had one that was denied 5 times. They were different from most people because you know what they didn't do? They did not give up. They actually called us and says, "Is there anything you can do to help us?" And yes, we were able to help them. We were able to protect some of the assets. Candidly, we protected much less than what we could have if we were brought in at the beginning. But we were still able to help because we got an application approved. The tools that can protect your family savings. So, what specific tools does an elder law attorney actually use in a crisis? There are several, and the right combination depends entirely on the circumstance that the family is facing. Asset protection strategies like certain types of trust can legally shelter assets from being counted towards eligibility. Spousal protection rules can be used to ensure that the healthy spouse keeps enough resources to maintain a reasonable standard of living, one that the state thinks is reasonable. Strategic spending on allowable expenses like medical bills, home modifications, prepaid burials and funerals can reduce countable assets and help meet eligibility thresholds much faster. In some situations, converting non-exempt assets, such as a retirement account, is a key part of the strategy. Yeah, you heard me correct. Your retirement account is expected to pay for your spouse's long-term care needs. It's not your account, it's their account. There are also rules around how income is treated and how resources can be restructured that most families would never know about without seeking the advice of a professional elder law attorney. And this is exactly why having an experienced attorney matters so much in these cases. These aren't strategies you find in a Google search or by using AI. They require someone who understands the interplay between state law, federal law, tax rules, and agency policies, all at the same time. Why you should never try to navigate this alone. I have seen families try to handle long-term applications on their own, and almost every time it ends up costing them more than if they had hired an elder law attorney from the beginning. They miss deadlines. They make transfers that trigger penalties. They fill out the applications incorrectly and get denial letters. Or they get requests for additional information that can go on for months. And while they are sorting through all of that, what keeps happening? The bills for long-term care keep piling up. The cost of living keeps piling up. Long-term care planning, especially in a crisis, is one of the most complex areas of law that is out there. The rules change, the calculations change, the numbers are complicated, and the consequence of getting it wrong are severe, not just financially, but also emotionally. Families are already dealing with the stress of a loved one's health declining and what to do to help them. Adding on top of this a legal and financial nightmare is not something that one should have to go through. That's what we're here for. Here's a story. Well, I kind of think it's a funny story. You might not. Once, I was called into a judge's chamber. The judge was close to retirement, and he thought it would be a great idea to take an easy legal job in retirement, that of being an elder law attorney. So after we got done discussing what an elder law attorney does, the judge made a decision that he decided that he was going to, in retirement, instead of being an elder law attorney, he was going to try murder trials because it was much easier than being an elder law attorney. An elder law attorney is one who focuses on crisis, long-term planning, and can provide clarity when everything feels chaotic. They can protect assets that families assumed were already lost, and they can guide you through the application process so that your loved one gets the care and the needs are met without you having to lose everything that they've worked their entire life for. Even in the worst situations, we can often protect a portion of the family's assets. Not everything, but far more than most families expect when they first walk through our door. If someone in your family needs long-term care right now and you don't know how you're going to pay for it without losing everything, call us at 636-456-2345 for a free consultation. Even if you think it's too late, it might not be. We look at your situation and show you exactly what can still be protected. And if it can't, we tell you that too. If you found this to be helpful, be sure to like and subscribe for more guidance on protecting your family and planning for the future.